Are you ready, Hari? For the a bigger reach, we are doing live streaming also. May I start, sir?
Yes.
Namaste, Vanandal. I am Sridevi Champani, founder of Yagna Legal. Today need of the hour is to know about the new laws. So when I requested today's speaker that Krishnaya Garu to introduce us about new Indian Evidence Act, he accepted to give lecture on the same. And now we are going to conduct a 30 days program for the same to understand each and every part of the same. So I request Hari to introduce ourselves.
Thank you. Thank you, madam. Namaste, sir. Welcome, one and all. Good morning. Yagna Legal is a reputable law firm based out of Andhra Pradesh and Telangana. Yagna Legal is led by Srimati Sridevi Champani Garu, who is on call with us today. Yagna Legal specializes in civil, criminal, revenue, matrimonial, and service-related matters. As a part of a social commitment and a social responsibility towards the legal fraternity, Yagna Legal has volunteered to provide free learning programs that support the intellectual development of upcoming advocates in both academic as well as practical aspects of the legal profession. And Yagna Legal is excited today to announce that, as Madam mentioned, a 30-day live lecture series 30-day live lecture series in Bharatiya Sakshya Adhiniyam 2023, along with the Indian Evidence Act 1872. This series is designed to enhance your understanding and application of these crucial laws. And the session will run from June 2nd, 2024 to July 1st, 2024, every day morning at 7 a.m. And our eminent speaker and our mentor and who is going to be in helping us in this journey of learning new evidence laws in comparison with the old ones is none other than our retired Justice Krishnaya Garu. Very warm welcome, sir. And to give a brief introduction about our speaker today, is born in 1960 and a son of a freedom fighter, and who studied in Ongole Law College, VR Law College, Nellore. Practiced from 1983 and joined as JCJ and 1st of May 1989 at Putturu, and promoted as senior chief judge in 2002. Worked as a rent controller and juvenile magistrate during 1997 and 98 to 2000. Stood first in accelerated promotion test in 2012. Worked as judge in Visakhapatnam and been a chairman of Industrial Tribunal Godavarkani, principal judge at Mahbub Nagar, and Hyderabad retired principal district judge Nellore in 2020. I'm proud. I'm really happy to welcome you to the class, sir. Thank you so much for giving us this opportunity to learning along with you.
Thank you. Can I start, madam?
Yes, sir.
Yes. So, good morning to all the participants and also the organizer program, Sridevi Garu, for making elaborate arrangements to see that more and more people try to listen to this. I'm given to understand that practicing advocates, law students are mostly part of this audience. Evidence Act is the key which opens us into every trial, every argument, and every drafting. it has got several facets. It is not confined to just a perusal of some of the important provisions of Evidence Act. It is the key with which we can decipher a case. Whether you are drafting a plaint, whether you are drafting a written statement, whether you are arguing a criminal case, whether you are prosecuting a criminal case. Therefore, as we travel from one section to another, we will realize that there are more things to be learned than just reading some of the leading judgments on Evidence Act. I think I will be able to give you an approach, a correct approach, a legal approach, and a practical approach to the application of Evidence Act as advocates, to the understanding of each provision, its implications, its applicability. Now, before that, now we are going to have this Bharatiya Sakshya Adhiniyam from 1st July. Let us see what exactly it is going to change. You are all aware that most of the provisions are kept intact, but all the same, let us see the objects and reasons directly, because that's an elaborate statement of objects and reasons given for Bharatiya Sakshya Adhiniyam. Now, Sakshya, it's a Sanskrit word as well as a Telugu word as well as Hindi word. It literally means evidence or testimony. Therefore, it's quite normal for us to have such a heading of the Act. Now, first thing is the definition of evidence is expanded, and electronic or digital record as evidence having the same legal effect, validity, and enforceability as any other document is given. And also the scope of secondary evidence is expanded to include copies made from original by mechanical process, copies made from or compared with the original, counterparts of documents as against the parties who did not execute them, and oral accounts of the contents of a document given by someone who has himself seen it. Therefore, keeping in view these two changes and one or two omissions which relate to the colonial area, we will see how the new Act unfolds, and also we will refer to the relevant and comparative provision under the Indian Evidence Act, because the case law is going to be only under the Indian Evidence Act, and which is still very much applicable. Now, as far as short title is concerned, the same section 1, and in the short title, this act may be called the Bharatiya Sakshya Second Abhiyan 23. It applies to, now applicability, you please note the wording. All judicial proceedings in or before any court, including courts martial, but not to affidavits presented to any court or officer, nor to proceedings before an arbitrator. Therefore, it applies to all judicial proceedings before any court, but not to arbitration proceedings. And then, of course, it shall come into force on such day as it is. Now, in every act, in the first few provisions, you will have the section relating to definitions. Now, we'll read the definitions and then we'll go to other sections. But my request to you is, when I am pointing out certain definitions, which will again come in some other provision, then you have to underline this word, which is again used in other provisions, other sections of the Act. and then you apply that. For example, if you go to section 114 of the old Evidence Act, or it is equal to 119, may presume. May presume is something defined here. Therefore, we should bear in mind what the definition says when you again come across the same concept in another section. Is it may presume? Is it shall presume? What is its effect? The beauty of Evidence Act is most of the sections are very compact, very simple, except one or two sections. But they are pregnant with meaning, very effective words are used, and those words have to be marked. What are the important words, key words used in every section, which will differentiate them from other sections and which will also give us the main thrust of the section. Now let us see what are the definitions. Court includes all judges and magistrates and all persons except arbitrators legally authorized to take evidence. Therefore, whoever is legally authorized to take evidence, and then the arbitrator doesn't come. In the before an arbitrator, the Evidence Act does not apply. Now we have this definition of conclusive proof. You see, this is where not only a definition, but also a shutting off of evidence when a fact is conclusive proof is provided. Now, one party conclusively proves a fact before the court. The other party cannot let in any evidence as against the same. That is what the section says. Means where one fact is declared by this adheniyam to be conclusive proof of another, the court shall, on proof of one fact, regard the other as proved and shall not allow evidence to be given for the purpose of disproving it. Therefore, this is one definition which debars another party from letting in evidence to disprove something which is conclusively proved. Therefore, when you prove one fact and it conclusively proves another fact, the question of again letting in evidence regarding this conclusively proved fact does not arise. Therefore, here is a provision which not only gives a definition, but it also makes us alert as to the objection regarding unnecessary evidence being let in to disprove a fact which is conclusively proved before the court. Now, this is something, suppose you, in a particular case, you have conclusively proved certain fact, and then the other side still wants to come forward with some evidence. I will, in the course of my subsequent lectures, I will point out how that happens and what are the judgments which support or which enunciate or which delineate this concept. Then disproved, no, it's not a disproving of a case. It is disproving in relation to a fact. Means when after considering the matters before it, the court either believes that it does not exist or considers its non-existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it does not exist. Oh, there are three keywords in this section. We are talking of a fact being disproved. The court believes that a fact does not exist. Or the court comes to the conclusion that it considers its non-existence so probable that a prudent man will not be. ఇది ఎవరైనా నమ్ముతారా అంటాం మనం. అంటే ఏంటి, అక్కడ we are indirectly saying that a prudent man will not believe it. If somebody says something which is not believable, then the answer from us, the response from us, no cheppedi evaraina nammutara. Therefore, it is a natural reaction or response from an ordinary prudent person. That is what is incorporated. It is R. The court does not believe that it does not exist, or considers that a prudent man will not believe it. Now, what is the court considering here? What is the word used here, key word used here? Considering all the matters before it. When after considering the matters before it, if it is a civil case, you will consider the pleadings, the evidence, documents, answers given under section order 10, or interrogatories, or whatever it is. Therefore, there are a whole lot of things which have to be considered when you want to either prove or disprove a fact. The disprove or proof of a fact or proof relates only to a fact, not to the case. That is one thing. Second thing is, the other key word is, please note, under the circumstances of the case. Now, under the circumstances of the case, we are trying to see whether a fact is disproved. In the assessment relating to the proof or disproof of a fact is in the background of circumstances of the case. That is why when you consider certain settled principle of law, they emanate from this. When there is direct evidence of an offense, motive is irrelevant. When there is a free fight between two parties, right of private defense does not exist. When there are negligible injuries on the accused and when there are grievous injuries on the victims, then right of private defense may not lie. So all these things, now you relate to, now I have given you 3 examples. You relate them to the circumstances of the case. Is it not? It is only in the circumstances of each case that we try to assess whether a fact is proved or disproved. By considering matters before it, the court may also consider 313 CRPC examination, whatever defense evidence that is latent in a criminal case. Therefore, the section does not say considering the evidence. The section says considering the matters before it. Therefore, what are the keywords? Considering the matters before it, court believes that it does not exist, or a prudent man considers that a prudent man will not believe this, and in the circumstances of the case. Particular case, to act upon the supposition that it does not exist. So, taking into consideration the circumstances of the particular case, if the court comes to the conclusion that a fact is disproved, then the fact remains disproved. So, another thing is, now we come to the definition, document. Now, document is something which is popular in our popular perception, something written on a paper. Every definition is coached in such language. It is put in such a language. The words are used in such a sense that it will take into its fold everything relating to that definition. Now we will see how this definition of document gives us a comprehensive idea of whatever is produced before the court as a document. Means any matter expressed. Any matter, it's not a writing alone. It's not a writing alone. Any matter expressed or described Again, described means it may not be a writing. Or otherwise recorded upon any substance. Otherwise recorded upon any substance. There are number of cases, civil suits, in which a party comes to the court. I have given a donation for the construction of the mandapam in this temple. There is a plaque on which this donation is recorded. Now that is removed, or that is going to be removed. Therefore, please give me a permanent injunction that the plaque should not be removed. Now, what is it? It is something recorded on a substance. By means of letters, figures, or marks, or any other means, or by more than one of those means, intended to be used, or which may be used for the purpose of recording that matter, and includes electronic and digital records. Therefore, now we have electronic and digital records that has been added. Basically, to give you a practical example, I came across a small receipt in a civil suit. That receipt is for an amount of rupees 45 rupees or so. It may not bear a date, it may not bear the signature of anybody, but still in relation to other evidences, I consider that as a document because something is recorded there. Therefore, you may take any, suppose something is written on a old temple as to who had built it in which century, archaeological evidence. Therefore, it may be letters or figures. You will see in the subsequent provisions a section which says that a person may be using a word in a particular sense. Smugglers may be using a word in a particular sense. I sent you something without saying it is money or some smuggled goods, he may use another word. That is also evidence. If that is recorded on a document somewhere, maybe on a wall or whatever it is, then it becomes evidence. Therefore, expressed or described or otherwise recorded upon any substance by means of letters, figures, or marks. Marks is something which also amounts to a document. Now, let us see the illustrations. I am making it clear to all of you that I am going to lay a lot of stress on the illustrations part of the Evidence Act, because they are the pointers to what is stated in the section. And sometimes if you read the illustrations first, then you will know the meaning of the purport of the section, the applicability of the section in a better manner. Now let us see what these illustrations are. Words printed, lithographed, or photographed are documents. So very simple, direct. A map or plan is a document. An inscription on a metal plate or stone is a document. Suppose a silver vessel is stolen, it is recovered. Suppose it is inscribed, presented by so-and-so to so-and-so. Then it is a document as far as ownership of that vessel is concerned. A caricature is a document. You know what is meant by a caricature? It's a sort of satirical drawing of a person or something. And that caricature is also a document. It may come with regard to the cases of defamation or say affecting the modesty of a woman and all that. Now, electronic record electronic record on emails, server logs, documents on computers, laptop or smartphone, messages, websites, locational evidence, and voicemail messages stored on digital devices or documents. Now, in this definition of, in this illustration, electronic record, because we already have document includes electronic and digital records. Therefore, this illustration, in fact, expands what is stated in the definition. It is electronic record on emails, server logs, documents on computers, laptop or smartphone, messages, websites, locational evidence, and voice mail messages stored on digital devices or documents. Therefore, whatever type of electronic evidence which we are now coming across, then now you are recording this program. It becomes electronic evidence. And then the keyword evidence. Evidence means and includes all statements, including statements given electronically, which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, and such statements are called oral evidence. Now let us see what the previous evidence act stated about this same definition, so that we can perceive, we can point out what is the exact difference between the present definition as against the new enactment. Now, in the old enactment, evidence means and includes. That is normal. All statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry, such statements are called evidence. Then all documents, including electronic records produced for the inspection of the court, such documents are called documentary evidence. Now here in the old act, the definition of evidence is virtually divided into statements made before the court and documents produced before the court, including electronic records. Now here, let us see all statements, including statements given electronically, which the court permits or requires to be made before it by witness in relation to matters of fact under inquiry, and such statements are called oral evidence. Therefore, electronically made statements are also included in this definition. Then all documents, including electronic or digital records. Now see the addition of the word digital. Electronic or digital records produced for the inspection of the court, and such documents are called documentary evidence. Therefore, what is now added is an electronically statement given electronically, which the court permits or requires to be made. The court may sometimes require some evidence to be produced before it. It has got that power. No, this is the simple change made in the definition of evidence, but it will have a lot of practical applicability when the act comes into force and when a trial takes place. Then, fact means and includes anything, state of things, or relation to things capable of being perceived by the senses. Now, the word used is perceived by the senses. Somebody comes and stands before me, and even before he says anything, I can see that you are suffering from fever. I can see that you are sick. I can see that you are so weak that you are unable to stand. What is this? It is a perception of the senses. You have immediately perceived that person standing in front of you is sick or ill or suffering from fever. This perception is something related to the coordination of what you see and what you immediately sense and come to a conclusion. So, anything, state of things or relation of things capable of being perceived by the senses. So, if the senses are, if something is capable of being perceived by the senses, then it's a fact. Now, why these words are used? Anything capable of being perceived by the senses. Why this action does not stop there? State of things. If you go to 114, there is a presumption. One of the presumptions is that if a particular set of facts is said to be in existence on a particular day, the presumption is may presume that it continues. That can be related to possession also. We'll come to it. But now, state of things or relation of things. This again is a very important word. You can't have a single fact in relation to something which has taken place or which is sought to be proved. It is always going to be a combination of certain documentary evidence, moral evidence, certain circumstances, certain things which happened in the past, which have a bearing now, and all these things, relation of things, that's a very important thing, important word in the definition. Any mental condition of which any person is conscious. About 2 years ago, I called a person and told him about the behavior of X. Sir, please don't tell me all that. I know that person is mad. So this is something which the senses are able to see, that mental condition of which any person is conscious. The word used is conscious. He is conscious of that mental condition. There, it relates to something, relation of things. But here, it is only the mental condition of which I am conscious. The witness is conscious. Somebody is conscious. Now, illustrations. That there are certain objects arranged in a certain order in a certain place is a fact. Now, I request at least one of the participants to answer to which part of the definition this illustration relates. Just it's an informal question.
Relation of things.
Yes, relation of things. That is how you read the illustration, you go back to the definition. Illustrations are, of all enactments, illustrations under the Evidence Act are very, very important. See, the sentence is so simple. There are certain objects arranged in a certain order in a certain place is a fact. Now, I will also expand that. We are seeing in movies, somebody is down the hill, somebody else is up the hill. He is aware that certain logs are tied down in a bundle and placed there. He will simply release the logs. They fall on the person and he is either injured or something happens. Now, what is it here? It is arranged in a certain order. So that becomes a fact. Then that a person heard or something is a fact. heard or saw something is a fact. That is, of course. But again, what I heard may be admissible, may be relevant, or may not be relevant, depending on the circumstances. It may attract Section 6 of the Old Act, or it may amount to something hearsay. But in other illustrations, in several other illustrations, you will see that the words spoken to, they are part of the transaction. They are very much relevant. We will come to them when we read the other illustrations. And then that a person said certain words is a fact. This is hearing. Illustration number 2 is hearing or seeing a fact. That a person said certain words is a fact. He told me that he is going to divorce his wife. He is fed up. He doesn't want to be with her even for one moment. Come what may, I will not live with her. Come what may, I will not allow her to go out of the house. Oh, if these words are heard by somebody, spoken to, then they may reveal the intention of this man, the motive for doing some crime against. Therefore, all these are facts. That a person holds a certain opinion, now we have come to this opinion part, has a certain intention, acts in good faith, or fraudulently, or uses a particular word in a particular sense, or is or was at a specific time conscious of a particular sensation is a fact. On the day 1 month ago when he said something, I did not notice particularly, but on that day he was in a particular mood. He was coolly saying that he will do something.
Single largest party కూడా 300 above. ఎవడు
So therefore, please see this illustration. It expands the definition. Facts in issue means and includes. Now this is an inclusive illustration. Sorry. No, that a person holds a certain opinion, has a certain intention, acts in good faith. He acted in good faith. This good faith comes when you consider, say, private defense or some other thing. Or fraudulently. Or uses a particular word in a particular sense. That's what I was saying. He will use that word. There is a old Telugu movie in which the villain says, నాకు నీ మీద విరక్తి కలిగింది అంటాడు. అంటే చంపేస్తానని అర్థం. చాలా పాత సినిమా. Or uses a particular word in a particular sense, or is or was at a specified time conscious of a particular sensation. Here the illustration also speaks of a sensation. It is a fact. Now you see how everything which is generally perceived as part of evidence, generally treated as part of evidence, it is given here. But what is expanding this is uses a particular word in a particular sense. Or is or was at a specified time conscious of a particular sensation is a fact. Therefore, this illustration expands what is actually given in the definition part. Now, these are 4 illustrations. I hope I have been successful in impressing upon you the practical application of the illustrations under each provision of the Evidence Act. They also have to be read slowly, digesting their meaning, and what is thought to be conveyed by this definition, this illustration. And then we will come to facts in issue. means and includes any fact from which either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. This is a simple word. Facts and issue. In every dispute, there will be two parties. One this side and one on the other side. Prosecution, defense, plaintiff, defendant, petitioner, respondent. Certain facts are in dispute. They are in issue. What is contained generally by way of issues in a civil suit is different from what is stated here. Facts is issue. Sometimes, let us take the example of the valid execution of a will. It includes the state of mind, the health of the executant, his mental condition, his ability to actually make a will. That is one fact in issue, one fact to be proved. And then attestation is another fact. Therefore, when you consider one issue in a civil suit, the issue may contain several things. But facts in issue means in relation to other facts, the court comes to the conclusion that something is, some right is there, right is not there, right is only to certain extent. Let us again see the words. Means includes any fact from which either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. Therefore, one asserts, one denies, and then the court will decide. What the court will decide? Existence, non-existence, right, liability, nature, extent. Suppose there is a pro note suit. Defendant says, I borrowed only 50,000. Plaintiff says, I took a pro note for 1 lakh. And the court ultimately comes to the conclusion that the pro note is supported by concession only to the extent of 50,000. Then it is deciding the nature or extent of any right. Now, in any suit or proceeding, you please note one thing. In the Evidence Act, the word suit is used in certain sections. Therefore, here the word suit is used or proceeding necessarily follows. So when the court decides certain facts in issue, then a conclusion comes. A conclusion as to the rights or liabilities of any party, nature or extent, existence, non-existence, everything. Therefore, this is a key definition which you have to bear in mind. Now, what is the manner in which this court comes to that conclusion? Any fact from which either by itself or in connection with other facts. Let us take, for example, the law relating to dying declarations. The law is that if the dying declaration is reliable, that sole dying declaration can form the basis of a conviction. Therefore, how this person died, who killed him, fact in issue, then that fact in issue is decided by a single thing. Or sometimes you may require some more evidence. Then explanation. Whenever under the provisions of the law for the time being in force relating to civil procedure, any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a fact issue. Now the explanation directly refers to civil procedure. any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a fact issue. Again, in pleadings, you will come across, in civil suits, you will come across this contingency. The court records an issue of fact. The fact to be asserted or denied in answer to such issue is a fact issue. Suppose some conclusion has to be arrived at, something else has to be decided, then that again is a fact issue. And then we will also see illustrations. A is accused of the murder of B. Now I request you to bear in mind the wording in illustrations for two purposes. One, as I have already told you, it makes us understand the true meaning of the definition. The second is, whoever is appearing for exams, the question will be like this only. What we ordinarily see is lot of pleadings, lot of facts, but in the question paper you won't see so many things. Illustrations are also like that. A is accused of the murder of B. At his trial, the following facts may be an issue. Now, simple. The issue before the court is what happened? Who murdered? A is accused of the murder. Now, that A caused B's death is one fact and issue. That A intended to cause B's death is another fact and issue. Intended to cause, because that intention again takes us to the difference between murder and culpable homicide. That A had received grave and sudden provocation from B, again it relates to whether it is murder or culpable homicide. That A at the time of doing the act, at which caused B's death, was by reason of unsoundness of mind, incapable of knowing its nature. Private defense. General exceptions. As a defense, unsoundness of mind. Now these four illustrations you please see, gentlemen. The fact and issue is whether A committed murder of B. All these are again facts and issue. Without deciding which, you cannot decide the extent of liability. The extent of liability, is it murder or is it culpable homicide? That is contained in these illustrations 1, 2, 3, 4. Oh, this is, I think I have made myself clear as to what exactly has to be considered in a trial to come to for the court to come to a conclusion regarding facts and issue. And then may presume, whenever it is provided by this adhiniyam that the court may presume a fact, it may either regard such fact as proved unless and until it is proved, or may call for proof of it. Now, this definition has a very important tag at the end of the sentence. The court may presume whenever it is provided by this adhiniyam. It must be a presumption which is contained in this act, that the court may presume a fact. It may either regard such fact as proved unless and until it is disproved, or may call for proof of it. Now the court will presume, may presume a fact as provided under this act, under any provision, until it is disproved, or the court may call for proof of it. Therefore, compared to shall presume, may presume is a situation where the court will not readily believe something, will not readily presume something, even though it is provided in this act. And when you consider the definition of shall presume, you will note the difference. Not proved. A fact is said to be not proved when it is neither proved nor disproved. Generally, in criminal cases, the court will say the prosecution has not proved the offense. The court will not say the accused has disproved the prosecution version. And then proved. A fact is said to be proved when, after considering the matters before it. Again, matters before it. The court either believes it to exist or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. The same wording is used in the definition of disproved. In this section also, considering the matters before it. And then you come to the definition of relevant. Relevant is something which is the sine qua non for considering the evidence. It must be relevant. Section 5 of the old Act and Section 3 of the new Act, they clearly laid out that only something which is declared to be relevant under the Evidence Act can be taken note of. A fact is said to be relevant to another when it is connected with the other in any of the ways referred to in the provisions of this adheniyam relating to the relevancy of fact. Any of the ways referred to in the provisions. Therefore, the Act has to say that in a particular manner, in a particular situation, in a particular fact situation, in a particular circumstance, something is relevant. Let us say, for example, there is no provision relating to dying declaration in the Evidence Act. Sir, X before his death has said like this, I have heard it. It's not direct evidence. The person who has made that statement is no more. Only because the Evidence Act declares it as relevant, admissible, then it becomes evidence. Then it becomes relevant. Therefore, what is the meaning of the phrase relating to in any of the ways referred to in the provisions of the adheniyam relating to relevancy of fact? As we go through other sections, we will see this is relevant, this is relevant, this is relevant, this fact can be presumed, this fact, the court shall presume this fact. All these things, they come in the foregoing sections. Therefore, in any of the ways referred to in this subject. Therefore, the court clearly lays down what is relevant. Shall presume. Now, shall presume, I will read this definition. I want one of you to point out what are the key words in this section. Whenever it is directed by this adheniyam that the court shall presume a fact, it shall regard such fact as proved unless and until it is disproved. What is the key word in this definition? Anybody, please?
It's the conclusive proof.
Yes?
It's the conclusive proof.
Shall presume. Definition. What is the key word?
Until it is disproved.
Yes, anybody else?
Shall regard such fact as proved.
Okay, you compare with the
Presumption of facts.
wording used in may presume and shall presume. We are aware of the usage of may and shall when we use.
Shall
Yes,
is
sir.
mandatory. Shall is
Shall-
mandatory. May is
May.
presumption.
మే చెయ్యొచ్చు చేయకపోవచ్చు కోర్టు చెయ్యొచ్చు డిస్క్రిషన్
Whenever
మే
it is provided by the Sadhaniyam. Yes, please.
కోర్టు షెల్ కోర్టు మే కోర్టు షెల్ చెయ్యొచ్చు చేయకపోవచ్చు
Directed by the court. Directed by the adenium.
Directed by the court is the essential difference between may presume and shall presume.
షెల్ అండ్ మే
Provided by the Sadhaniyam, directed by this court.
There is a difference. Provided,
A
directed.
particular section directs us to presume certain things. Whenever it is directed by the Sadhaniyam, that the court shall presume a fact, it shall regard such fact as proved. It will not call for further proof as in the case of may presume. This proof is something which is common to both. But in may presume, provided under the Adheniyam, and also court may call for proof of it. Here, if there is no attempt on the part of the other side to disprove the presumption, then it remains there. The court will not call for any further proof. Because there is a direction in this Adheniyam that court shall presume certain facts. Clear? Clear?
Yes, sir.
So this is the way in which we have to go on assimilating the change of certain phrases or words which make an essential difference to the meaning and applicability of a certain provision.
Sir, I
Yes.
just have one doubt in this regard. So under shall presume, the court is not going to use its discretion or whatever as it may presume. So the onus is on the other party to prove that it is disproved, right?
Yes, if the other party has an option to disprove it. In may presume, even before the other party wants to disprove it, the court may call for proof of it.
Right. The court is not going to be proactive here.
That contingency is not there in shall presume.
Right.
That option is not there in shall presume.
Right.
The option to disprove is there in may presume and shall presume. But the option to call for proof of it, that's why I said or may call for proof of it. The last wording in may presume is an option given to the court depending on the fact situation. Therefore, it is a situation where the court will not readily presume something, even if it is provided under the Adheniyam. In this shall presume, the Adheniyam directs the presumption of a fact.
Some more exams are required to have the clear understanding for the new upcoming students, sir.
No. When we go through the other sections, we will see what is section 114 presumptions, other things, then we will elaborate.
Okay,
We will
sir.
elaborate, no problem. That is why the Evidence Act sees to it that nothing goes beyond the provisions. Whenever it is provided by this Adheniyam, whenever it is directed by this Adheniyam. Andukane, again you note the words. When the definition relevant, a fact is said to be relevant to another when it is connected with the other in any of the facts, in any of the phase referred to in the provisions. Therefore, the Act goes on referring to certain things, certain fact situations, certain contingencies, certain types of suits. Then the relevancy is decided with reference to what is contained there. It never goes beyond the provisions. And then words and expressions used herein and not defined but defined in the IT Act. The Bharatiya Nagarik Suraksha Samhita 2023 and the Bharatiya Nyaya Samhita 23 shall have the same meaning as assigned to them in the said Act and Samhitas. Now, previously there was a in the old act, the expressions certifying authority, electronic signature certificate, electronic form, electronic records, information, secure electronic record, secure electronic signature, and subscriber shall have the meaning respectively assigned to them in the IT Act. Therefore, certain definitions are particularly noted in the old act. Now here, words and expressions used herein and not defined but defined in the IT Act. The Bharatiya Nagarik Suraksha Samhita and Bharatiya Nyaya Samhita shall have the same meaning as assigned to them in the said Act and Samhitas, provided that any reference in this adhiniyam to the Bharat Nagarik Samhita or the Bharat Nyaya Samhita shall be construed as a reference to the Bharatiya Nagarik Suraksha Second Samhita 2023 or the Bharatiya Nyaya Second Samhitas 2023 respectively. Therefore, this is something which elaborates the definition with regard to electronic evidence. You have to make use of the definitions in the IT Act or the other two enactments, which are Nagarik Suraksha Samhita and Nyaya Samhita. These are the definitions. Now we have completed more than 1 hour, and I will go to chapter 2. It is part 2, chapter 2. Now we have completed part 1. This is important, as I told you. Relevancy of facts. Evidence may be given of facts in issue and relevant facts. That's all. Evidence may be given of facts in issue and relevant facts. Evidence may be given in any suit or proceeding of the existence or non-existence of every fact in issue and of such other facts as are hereinafter declared to be relevant and of no others. Therefore, whenever you want to introduce something in the evidence, some fact, you want to prove some fact, or you want to disprove certain fact, or you want to introduce evidence that something does not exist, then it must be declared as relevant by this adhiniyam and of no others. You can't travel beyond what is stated to be relevant under the Evidence Act. Now this explanation. This section shall not enable any person to give evidence of a fact which is disentitled to prove by any provision of law for the time being in force relating to civil procedure. Now, if the civil procedure says that you have to file a document which is relied upon in the written statement, along with the written statement, or it contains a provision in relation to certain evidence to be produced, then that cannot be denied. The section being simply because it is relevant, it cannot override the restrictions placed in the Civil Procedure Code. Let us again read this explanation. This section shall not enable any person to give evidence of a fact which is disentitled to prove by any provision of the law for the time being in force relating to civil procedure. Or you may say that something is not specifically denied in the written statement, or something is admitted in the written statement. So certain contingencies are given in this explanation. Now let us see the illustrations. A is tried for the murder of B by beating him with a club with the intention of causing his death. Here the illustration, you please note the difference between the illustration which previously we have read about. A is accused of the murder of B. Here the illustration is different. A is tried for the murder of B by beating him with a club with the intention of causing his death. At A's trial, the following facts are ensued. A's beating B with the club, A's causing B's death by such beating, A's intention to cause B's death. Therefore, from a simple illustration, what has to be ultimately considered, what is relevant, that is given here. Then another illustration. A suitor does not bring with him and have in readiness for production at the first hearing of the case a bond on which he relies. This section does not enable him to produce the bond or prove its contents at a subsequent stage of the proceedings, otherwise than in accordance with the conditions prescribed by CPC. That's why I said certain facts they can be placed before the court, but there are certain restrictions in the CPC. There is a certain time frame. Therefore, if the CPC prescribes any such restrictions and the party does not follow those restrictions, then he cannot take advantage of this section and say this is relevant, therefore I am entitled to produce. This second illustration relates to the explanation. So I think there is no difference between these two illustrations given here under and the old act. And then old section 6, that is relevance of facts forming part of same transaction. Facts which, though not an issue, are so connected with the fact in issue are a relevant fact as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. Now, facts which, though not issue, they are not directly in issue. They are so connected with the fact in issue, are a relevant fact as to form part of the same transaction. Now, forming part of the same transaction are the keywords. They are relevant, whether they occur at the same time and place or at different times and places. What is the implication of using these words at different times and places? I will explain you again when I refer to the subsequent sections. The words are used with a particular implication. As I told you, we have to confine ourselves to the provisions of the Evidence Act with regard to relevance. Now here, relevance of facts forming part of the same transaction, but they may be or at different times and places. The transaction may be the same, but time and place may be different. Somebody may be threatening the victim from Hyderabad and somebody else may kill him at Guntur. They are part of the same transaction. I request you to bear in mind one important method of comprehending each and every provision, whether it is Evidence Act or any other act. Whenever you read a definition, you should be able to form an example by yourself. Therefore, and when you come across a particular example, you should be able to relate it to the particular provision, relevant provision in any act. It may be Evidence Act or any other act. That is the manner in which you have to look at the bare act. Why I am stressing on the explanation of each and every word in every section is, before we go to certain important judgments or latest judgments or whatever it is, let us try to understand the bare act. Let us try to understand as to the implication of the words used therein. Now let us see the illustrations. The illustrations will again make us to relate to the actual provision under section 4, which was previously section 6. A is accused of the murder of B by beating him. Whatever was said or done by A or B or by the bystanders at the beating or so shortly before or after it has to form part of the transaction is a relevant fact. Now we are talking of bystanders. Bystanders, where people just gathered there. So shortly or after it. Now, previously I said, illustrations under fact, that a person said certain facts words is a fact. Here, bystanders utter certain words. Either at the meeting or so shortly before after it as to form part of the transaction. We are not talking of something which the accused has done. We are talking of what the bystanders uttered. Let us say a person parks his motorcycle in such a way that it obstructs the opening of the gate of one house. Then a bystander immediately says, I know this fellow has unnecessarily provoked the owner of the house. I know what he will do. He will not spare anybody if there is an obstruction to his gate. And if the person in the house ultimately comes out and gives a beating to the victim, then those words uttered, they form part of the same transaction. They are relevant. He is only a bystander, bypasser. He is only standing there. But still, what he says, what is going to happen, or what is likely to happen, they are all important words. They are relevant facts. A is accused of waging war against the government of India by taking part in an armed insurrection in which property is destroyed, troops are attacked and jails are broken open. The occurrence of these facts is relevant as forming part of the general transaction, though A may not have been present at all of them. If you read the illustration under section 10 of the old act and section 8 of the new act relating to conspiracy, you will realize why this section 6 is connected with section 10. We have already stated in the definition whether they occurred at the same time, place, or different times and places. Now, these different times and places so at different times and places, that is what the illustration says. Property is destroyed, troops are attacked and jails are broken open, not at every place. Just 1 minute. Yes. So now we know why this word are at different times and places is used in section 4 relating to section 6 of the old act. Another thing is, though A may not have been present in all of them, therefore, certain relevant facts are introduced even though there is no direct connection with the accused. You may read after this class the illustration given under Section 8 of the new Act and Section 10 of the old Act. We will also consider it in due course. And then A sues B for a libel contained in a letter forming part of a correspondence. Letters between the parties relating to the subject out of which the libel arose and forming part of the correspondence in which it is contained are relevant facts, though they do not contain the libel itself. Again, the illustration, please note it. You are conducting a case either for the complainant or for the accused in a case of libel. A sues B for a libel containing in a letter forming part of the correspondence. Letters between the parties relating to the subject out of which the libel arose and forming part of the correspondence in which it is contained are relevant facts, though they do not contain the libel itself. So this is an illustration which directly refers to what is relevant in a case of libel. And then the other illustration is, the question is whether certain goods ordered from B were delivered to A. The goods were delivered to several intermediate persons successively. Each delivery is a relevant. Each delivery is a relevant fact. Meeru, please note, the first illustration relates to a criminal case. The second illustration relates to a criminal case, particularly a case of conspiracy. Third illustration relates to a suit for libel. And then the fourth illustration also relates to a civil suit. Therefore, when you go through the Evidence Act, you will find certain provisions which are common to both civil and criminal proceedings, and certain provisions which relate only to criminal cases, and certain provisions which relate only to a civil case, that too in a particular type of case. Therefore, the illustrations show you that you can introduce evidence with connected facts forming part of the same transaction. And the keywords are, it may be at different times at different places. That's why the question is whether certain goods ordered from B were delivered to A. The goods were delivered to several intermediate persons successively. Each delivery is a relevant fact. Don't tell me all that. Have you gone and delivered the goods to B? That is not the way in which that fact is proved. I have booked it in so-and-so parcel office. They have taken it to that place. From that place, so-and-so is supposed to deliver it to you. This is what happened. So these are relevant facts forming part of the same transaction, which ultimately either prove or disprove this. They are relevant. I'm sorry, the question is whether you have delivered to B. Don't tell me about the intermediate transactions. That is not the way in which we look at relevant facts. And then I think I am clear with regard to this illustration, this section, and the illustrations, as I told you, they give you an idea as to in what type of suit, what provision is relevant. In what type of suit you can introduce what type of fact, what type of evidence. Facts which are occasion, cause, or effect of facts in issue are relevant facts. This is a very section is of wide applicability. Of course, the illustrations relate only to criminal cases, but this section is of wide applicability. The words used therein are very profound. They need to be closely looked at, and they need to be applied to several types of cases, whether they be civil or criminal. Facts which are occasion, cause, or effect. Now these may be three simple words. Occasion, cause, or effect, these may be three simple words. But if you contemplate in your mind several cases which you may have conducted, several judgments which you may have read, several types of disputes which you may have noticed, you will find that invariably every dispute will have this occasion, cause, or effect. Ultimately, they will be there. And then the second phrase, immediate or otherwise, of relevant facts or facts in issue, or which constitute the state of things under which they happen. Both of them initially gave fist blows to each other. Suddenly one of them, like in cinemas, finds a big sword and kills the other fellow. Or which afforded an opportunity for their occurrence or transaction are relevant. What is this word afford? I cannot afford a costly phone. The meaning of this word afford here is I cannot purchase. I have no means. I have no money. But here the word afford is used in the sense certain things happen. This mostly comes in cases where a victim is found alone. Where a victim is found alone. Nobody is there. The accused finds her alone. Then it afforded him an opportunity to commit an offense against her. దోహదము చేయు అనేటువంటి అర్థం వస్తుంది. So I will explain this section more elaborately tomorrow. I'll also read the illustrations. Anything you want me to change the way in which I am explaining?
Are asking you people only.
Anybody, I am concentrating on the keywords in a section, the relation between sections, the manner in which ultimately you have to use them. As we go by, we will come across several sections which you need to know even to draft a suit. That is the beauty of Evidence Act.
Yes, sir. But first, we need to know the basics of it. Then only we could understand the deeper topics. I believe.
Yes.
And any suggestion from anyone?
Good
I
morning,
have a
madam.
doubt, couple of doubts. Okay.
Good morning, sir.
Good morning, Japani.
Sir, may I ask you one doubt, sir?
Yes,
Sir, one thing, sir. I am Rajendra Prasad from Hyderabad, sir.
yes.
There are some disputes between A and B, sir. So A provocated and sent C to kill B. But A was not present in the scene of offense. Now, how to prove that A was guilty?
That is అందుకని మన సెక్షన్స్ వస్తాయి కదా. Now you need to know the manner of proof in the Evidence Act, but whereas the definition of offense of abetting is an IPC.
But
in the coming sections and illustrations, you will notice all this.
okay,
You will notice all this. A person may be connected with an offense either directly or indirectly. Even if you take section 34 IPC, it is in furtherance of common intention. And
Okay.
there is a section, he cooperates with the accused for in committing the offense. The words used are different. We will come to it when we're dealing with IPC. But for the present, you please note that the illustrations, they will give you a great opportunity to apply them actually while conducting a case.
Okay,
I will, when it comes to explaining all that, I will come to it.
సార్ నమస్తే
Sir, I
సార్.
have a doubt.
Namaste.
సార్ ఇది ఇల్లస్ట్రేషన్స్ చదువుతున్నాం కదా సార్. ఈ ఇల్లస్ట్రేషన్స్ లో ఉన్న పాయింట్స్ ని మనం సైటేషన్ సేమ్ ఇల్లస్ట్రేషన్ సంబంధించిన మన కేసుకి సంబంధించిన రిలవెంట్ ఇల్లస్ట్రేషన్ ఏదైనా దొరికితే దానికి సంబంధించిన కనెక్టెడ్ గా సైటేషన్స్ తీసుకునే విధానం ఎలా ఉంటది సార్? ఇది ఓన్లీ ఇల్లస్ట్రేషన్ కదా సార్, దీనికి సంబంధించిన ఫ్యాక్ట్ మనకు ఎక్కడ దొరుకుతుంది?
అక్కడ ఇల్లస్ట్రేషన్ లోనే ఫ్యాక్ట్స్ ఉన్నాయి కదా.
కేసు కనెక్టెడ్ కేసెస్ రిఫరెన్స్ ఉందా సార్?
ఇప్పుడు ఇల్లస్ట్రేషన్ ఇప్పుడు మనం వీ హ్యావ్ గాన్ త్రూ రెస్గెస్ట్ సెక్షన్ 6 in the old act and section 4 in the new act. There are 4 illustrations. 4 illustrations pertain to 4 different contingencies. That's why I said whether it is in the bare act or in the question paper, you don't have elaborate pleadings. ఈ గూడ్స్ అక్కడికి అందాయా లేదా, మధ్యలో ఎవరెవరి మధ్య వెళ్ళాయి అనేది కూడా రిలవెంట్ ఫ్యాక్ట్ అంటున్నాడు. వేర్ ఇస్ ది నెసెసిటీ టు అగైన్ లుక్ ఫర్ ఏ precedent or a judgment unless it is necessary. Now we are only in the initial stages of the Evidence Act. As we go by, we will come across several illustrations. For example, you are conducting a marital dispute. What is relevant? It is there in illustration in one section. Therefore, for everything we don't need to have a precedent. In fact, are you aware of the commentary of Sarkar on Evidence Act, madam?
No, sir.
No sir, no sir.
You please go through the introduction given by an English judge for the Evidence Act. He has clearly stated the section is very much clear. Please try to understand that.
Sir.
Sir, I have a doubt.
Sir,
Okay,
namaste.
sir.
One request. Can I raise my hand and sir?
You do one thing. What I have seen. Okay, go ahead.
Sir, only one thing is tamaru tomorrow class enti evidence act lo ఏ sections first of all అది ఒక రోజు ముందల చదువుకొని illustration part కూడా చదువుకొని ఉంటే తమరు ఎక్స్ప్లెయిన్ చేసిన వెంటనే ఇట్స్ వెరీ ఈజీ ఫర్ ఈచ్ అండ్ ఎవ్రీ పర్సన్.
I will go through one section by in the serial order.
ఎస్ సార్, అదే తమరు ముందుగుండా చెప్పి ఆల్ ద పార్టిసిపెంట్స్ కి ఒక్కసారి గో త్రూ విత్ ద సెక్షన్స్ అండ్ ఇల్లస్ట్రేషన్ పార్ట్ అని తమరు ఒక గైడెన్స్ గా ఇచ్చినట్లయితే ఇట్స్ ఈజీ ఫర్ ఈచ్ అండ్ ఎవ్రీ పర్సన్ వెన్ యు ఆర్ ఎక్స్ప్లెయినింగ్ ద సేమ్. సో ఇప్పుడు ముందుగుండా చదవకపోవడం వల్ల వీళ్ళందరూ కూడా ఇది ఏంటి అదేంటి కాకుండా వాట్ ఈస్ కామా, ఇండియన్ ఎవిడెన్స్ యాక్ట్ లో కామా మీన్స్ ఎ లాట్, ఫుల్ స్టాప్ మీన్స్ ఎ లాట్. సో తమరు అట్లాగా డెఫినిషన్ పార్ట్ ని కూడా ఇది దీనికి ఇంత రీజన్ ఉంటుంది. సో ఇల్లస్ట్రేషన్ పార్ట్ వన్స్ తెలిస్తే సెక్షన్ వెరీ ఈజీ టు నో. ఇట్స్ మై ఒపీనియన్ సార్. అండ్ రిలవెంట్ బుక్స్ తమరు ఏమైనా సజెస్ట్ చేసి వీళ్ళని ముందుగుండా తీసుకోమని చెప్పిన ఆరల్స్ వాళ్ళు డౌన్లోడ్ చేసుకొని సర్కారస్ ఉంది, సర్కారస్ కూడా మొబైల్లో డౌన్లోడ్ చేసుకున్నా దేనిలో డౌన్లోడ్ చేసుకుని వన్స్ చదివితే దే కెన్ అండర్స్టాండ్ వాట్ ఈస్ ద పర్పస్ ఆఫ్ ఎవిడెన్స్ యాక్ట్, how it is useful in the civil side and criminal side. It's my opinion, sir.
now if I want you to tell me how it is useful in civil criminal cases, it becomes an overall assessment of the Indian Evidence Act. Now, because
Yes,
there are
sir.
30 classes, I am going by from section to section. You can read
Yes,
the
sir.
next 5 or 6 sections. Today I have dealt with so many sections. You can read the next 5 or 6 sections. I
Yes,
will
sir.
tell you at the relevant point of time which section will come to your aid in what type of case.
Yes,
My
sir.
intention is to draw your attention to the keywords used therein, to the manner in which certain words are used, how they are related to the illustrations, how that section is related to another section or another illustration in the Evidence Act.
Yes, sir. That's what I am
If you have
explaining.
if you have any doubts, you just send them to Sridevi Garu. She will consolidate and send them to me.
Sir, this is
Yes,
just
sir.
one.
That's
Thank
it.
you. I am now leaving
This-
the class.
Okay, sir. Thank you.
Thank you.
Thank you, sir.
Sridevi madam.
Yes. Actually, నాకు signals పోయాయి. Net లేకుండే.
Madam,
Okay.
good morning. My name is Shiva. I'm from Hyderabad. I'm an advocate. So one suggestion I would like to make. The suggestion
Yes.
is when sir is trying to talk about relevant facts or some other point with regarding to that, can he provide us a citation, a precedent, so that we can go through it? For example,
As far as
when you are-
presidents are concerned, some
Yes,
of
sir,
the
go.
presidents will have a discussion on several provisions.
Sir, my intention was, for example, when you initially started the topic, we were talking about the relevant facts, right, sir? When we were
Yes.
talking about the relevant fact, could you please give us a particular citation wherein it refers to a relevant fact? For example, we were talking about conclusive proof. There could be a citation with regarding to the conclusive proof as well. If you
Yes.
could refer us to
Yes,
that
sir.
particular citation.
I am in all my lectures. I am concentrating on drawing the attention of the listeners to the keywords used therein, why they have been used, what is the difference between may presume and shall presume, and then how to make your own illustration out of it. I will give citations. Citations, if you start citations, you can give any number. I will give citations only after selecting them. No, don't worry. But unless you go through what is relevant fact, what is it I have said today, the Evidence Act will declare what is relevant. And it will not admit anything and of no others. Therefore, as we go through, we will come across several types of relevant facts. It is not confined to one judgment.
Yes.
I will
Sir,
give case law. I am going to select case law with a lot of care and caution.
Thank you, sir.
Sir, I'd request one illustration in terms of section 4, sir, because in the new act in BSA, they have added or a relevant fact. Res gestae scope seems to have been expanded, not just in terms of facts and issue, or a relevant fact is what they newly added. So in practical terms, if you could just give a small illustration as to how it has affected section 4, that is erstwhile section 6.
Okay, I'll look at it tomorrow because we are already at tomorrow. I'll look at it.
Thank you, sir.
Thank you.
Thank you so much, sir.
Thank you.
And any other suggestions, you please, you can contact me.
Post them by way of messages.
Yes, sir.
Thank you, sir. Thank you so much, sir.
Thank you.
And,
Thank you.
And I request all the participants to.
Thank you, ma'am. Thank you, sir.
Thank you so much, sir.
Thank you.
Thank you so much, sir.
And message to the
Thank you so much, sir.
participants. Wait. I request you all, your presence in all the 30 classes, so that you can understand the topic in a proper perspective. right? Conducting this kind of program itself is a big challenge for us. And
Yes.
your cooperation is required. And you just need to
పైన
understand
కొంచెం మేడ చూసి అక్కడ మట్టి
mute చేయండి. Please understand, రేపటి నుంచి court start అవుతుంది. Many other issues we need to face. But I'm expecting participation of all these 180 members so that you'll understand the topic at least at this hour. From this day, we can change our fate through knowing this Indian Evidence Act. That means Evidence Act is very important in all the aspects, but to a practicing advocates. And any other
what could be the timings, ma'am? Same timing?
same timing, 7 to 8:30.
Okay.
I'm also a practicing advocate, practicing at high courts. Even then, I'm sitting here just to motivate you and to guide you in this aspect.
Thank you, ma'am. Thank you.
Right? And don't neglect. I repeat, don't neglect. Please attend the sessions on each day and note down whatever you understood, and come before coming, you read the relevant portion of the act so that you will understand the same. For these 30 days, please understand you are a student of law, right? And we are going to conduct for classes for even IPC and CRPC for the new acts also. And if you are cooperative, then only I can do something in that aspect also, right?
Yeah, ma'am. Sure.
Thank you, madam. Thank you very much.
Please
Ma'am,
make a challenge or an adventure or else anything. What may you think? Please note down. Please your attention is required here.
Sure, ma'am. Ma'am, I'm Madhuri Devi from Visakhapatnam.
Yes, ma'am. Namaste, madam.
Namaste, ma'am. Namaste. I'm also practicing advocate here.
Yes, madam. ఇవాళ మనకు కొంచెం లీజర్ గా ఉన్నాం కాబట్టి ఇంకో 5-10 minutes we can discuss. Even at least now you open your camera, whatever attire you are, so
Okay.
that we can have some interaction between us.
Yes, ma'am.
మనం వేరు కోర్ట్స్ లో ఉంటాము, వేరు సిచ్యువేషన్స్ లో ఉంటాము, మనం మాట్లాడుకోవడానికి కూడా ఆపర్చునిటీ దొరకదు.
Yes, ma'am.
At least this through this platform we can exchange our views.
Yes,
And
ma'am.
we have a WhatsApp group. 2 groups are there for previous contacts. We have a Yagna legal group is there, and now for these sessions we have another group, Yagna legal evidence, so on so. BVA and something, we have another group is there. If you are not there in the group, you please join and don't discuss anything except the topic.
Yes.
Right? Even related judgments you can post. Whatever the portion we have covered till date. Today we have only covered introduction. If at all any judgments you gone through, you please post it. And
Ma'am, it is the 30 days program you are saying,
yes, madam.
but there may be little disturbance for us due to the court attendance of our work.
Even I need to go nearly 30 kilometers every day to attend the court. I know the practical problems,
Yes.
but you need to wake up early. You need to finish the works soon as possible, and you need to sit before the class on that time. Even I attend a few online courses. One of such is Satvik movement something, where they specifically ask for entire desktop, entire table must be clear.
Oh,
You must have only one idea to attend the class. with a notebook and relevant material. They ask us to take a photo and post it in the group. Likewise, when we do dedicated with dedication only, we do the better things, right? This is a beginning, new beginning. We need to put ourselves. We need to do 100% so that some change will happen. Otherwise, we will be like this forever. Yeah, I have gone through a message or some pamphlet like for the extraordinary results, you need to change extraordinarily. Like this one message I have gone through. I will post soon after the class in the group. So really, you are expecting some change, some betterment in you. You need to follow the session with dedication.
As Sridev Madam, can I have an opportunity to discuss with you about this? What the other Madam requested us, if any chance is there, little early start also, we are ready for at least.
Actually, true. But for that also, some people they may ask for some adjustment. In fact, we are ready to conduct at 4 o'clock itself.
Okay.
They can't attend. That's why in a reasonable time we have fixed it.
So it's 7 to 8:30. It will be 7 to 8:30 approximately. Yes, right. Thank you. But it's you are doing very good job, ma'am. So it's very thankful to you because all upcoming whoever may be all whenever we are always learned friends.
Yes, madam.
Good. Wish you all the best.
Yes, madam. You please text me. In fact, నేను immediate గా wind up చేస్తాను. ఎవరో నెంబర్ షేర్ చేశారు. You please kindly share it to my WhatsApp so that I can note down and add it in the many of you I know personally. Yes, Chipa.
I just shared my
I
number,
request whoever is talking, try to open your camera so that we can identify you.
ma'am. The problem is I'm unable to.
Thank you, ma'am. Thank you, ma'am. Upin Surinena from Visakhapatnam. Thank you. Good lectures every day.
Every class with camera. Actually, if you without attention, if we here we can't understand the topic. We need to listen it, particularly when the class session is going on. But when we are very clear, we are chatting. So anything else?
What happened?
Sorry, sir. Disconnect అయింది.